Welcome to another episode of Knowledge is Power. Today we will be listening to Dr. Mrs. Challa Mahalakshmi on Divorce Act, which relates to the Indian Christians. Over to Dr. Mrs. Challa Mahalakshmi.
Divorce Act. This law relates to divorce and other reliefs and applies to the persons professing Christian religion who are residents of India at the time of presenting the petition. This act brought into force in 2011 with amendments to the previous act of 1869 relating to divorce and other related issues. Jurisdiction. Any party can file a petition in the district court or wherever available in family courts. Dissolution of the marriage and grounds for dissolution. Petition for dissolution of marriage by husband or wife may be filed on the ground that the respondent has committed adultery or ceased to be Christian by converting into another religion, or has been incurably of unsound mind for a continuous period of 2 years, or has been suffering from virulent and incurable form of leprosy for 2 years, or has been suffering from venereal diseases in a communication form, or has not been heard of as being alive for a period of 7 years or more, or willfully refused to consummate the marriage, or has failed to comply with the order or decree of restitution of conjugal rights for a period of 2 years, or has deserted the petitioner for a period of 2 years, or has treated the petitioner with cruelty to cause harm or injury to the petitioner, which is harmful to the petitioner to live with the respondent. A wife may also file a petition for dissolution of marriage on the ground that her husband has been guilty of rape, sodomy, or bestiality. Dissolution by mutual consent. Both the wife and husband can file a petition for dissolution of marriage together on the ground that they were living separately for 2 years and that they are not able to live together and that they have mutually decided and agreed that the marriage shall be dissolved. If a petition for dissolution of marriage is filed on the ground of adultery, the alleged adulterer shall be impleaded as co-respondent unless the petitioner is recused by the court from doing so. During the inquiry, if the court comes to a conclusion that there was no evidence to prove adultery and that there was collusion between the petitioner and any of the respondents, the court refuses to allow the petition. Reliefs that may be granted in case of contest. The respondent is entitled for dissolution of marriage if he or she proves that the petitioner deserted or committed acts of cruelty or that he or she is guilty of adultery. Nullity of marriage. Any party to the marriage may file an application for declaring the marriage null and void if the respondent is impotent or that the parties were within the prohibited degrees of consanguinity, whether natural or legal. If the petitioner or the respondent is lunatic or idiot, the marriage will be nullified. If either party to the marriage has a spouse living at the time of marriage, the marriage shall be null and void. Children born before the decree of nullity shall be legitimate and entitled to succeed to the estate of the parents. Judicial separation. In a situation where court cannot grant a decree of dissolution of marriage, the court may grant a decree for judicial separation on the ground of adultery, cruelty, or desertion, and such decree shall have the effect of decree of divorce. Any woman who is unable to maintain herself shall be entitled to alimony from the husband. A judicially separated woman shall be considered as unmarried in respect of any property which she may acquire or which may come to her or devolve upon her. Any such woman shall have rights to enjoy such properties as if she were an unmarried woman. A deserted woman is entitled to protection orders with regard to the properties acquired by her. Restitution of conjugal rights. If any party to the marriage leaves the society of the other without reasonable cause or excuse, on the application of the aggrieved spouse, the court directs the deserted spouse to join the conjugal society of the petitioner. In such applications, the respondent cannot plead for decree of judicial separation or divorce. A woman is entitled for interim maintenance and expenses of the proceedings in any petition for any relief pending before the court, whether filed by her or her spouse. Therefore, any woman shall file applications for sanction of support in the courts at the beginning of the proceedings. She shall be granted such consolidated money or such annual sum towards alimony as a permanent measure by the courts, and she may be granted monthly or weekly payments for her maintenance and support. The aggrieved spouse can file applications for custody, maintenance, and education for the minor children as interim measures or as permanent reliefs in a petition pending for dissolution of marriage, judicial separation, or nullity. The courts may also direct the children to be under its protection. Since the information furnished now is very brief and the provisions of the Act are elaborate, any individual who needs more information may approach a qualified legal professional or additional details, or they may approach us by calling us, and please visit our website for further particulars.